The recent ruling by the North Carolina Supreme Court has significantly impacted the legal liability of nurses in clinical settings. Traditionally, nurses have been shielded from legal action if they were following a physician's orders. This 90-year-old legal precedent provided nurses with a level of protection, assuming that physicians were the primary decision makers and thus bore the responsibility for patient outcomes. However, in a decision by the North Carolina Supreme Court, this precedent has been overturned. The court ruled that nurses can now be held liable and accountable for their actions, even when those actions are directed by a physician. The rationale behind this decision is that the scope of nursing practice has evolved over time. Nurses today are expected to exercise a degree of independent judgment, especially with the increased complexity of healthcare and patient care. The court acknowledged this evolution, suggesting that nurses are not merely executors of physician orders, but rather active participants in patient care who must assess the safety and appropriateness of those orders. So, what are the implications of this ruling? Number one, nurses must now be more cautious when following physician instructions. They are expected to independently evaluate the potential risk of any given order and ensure it aligns with best practices and patient safety standards. This may lead to an increased number of lawsuits involving nurses, particularly in cases where patients suffer harm due to treatments or interventions initiated by a physician order. If you are a nurse without nursing liability insurance, I highly suggest it. The second piece, this ruling highlights the growing autonomy of the nursing profession. Nurses must actively engage in critical thinking and decision making, balancing their professional judgment with physician directives. In practice, this could mean nurses refusing to carry out orders they believe are unsafe or requesting further clarification from physicians. The third point here, as the expectations for nursing practice rise, so does the responsibility nurses bear. Nurses may need to document their assessments more thoroughly to protect themselves legally. They may also need additional training on legal liabilities and patient safety to navigate this new landscape effectively. So, in conclusion here, this shift places nurses in a position where their independent clinical judgment is as critical as a physician's, amplifying the need for vigilance, documentation, and ongoing education in both clinical and legal aspects of care. The consequences of this ruling could extend beyond North Carolina, potentially influencing similar cases and legal frameworks in other states.